mic you? They want to. Okay. I think Laurel's starting us off, right? Laurel, if you want to come up and in position, and then we'll just go from there. And this thing is completely flexible, so tell me when you're ready, and the control room will tell.
Okay.
Okay, you ready on our cue? When we know we're rolling and recording. Ready to go. Okay, on your cue, you just can begin.
Good evening. As president of the American Bar Association, it is my pleasure to welcome you today to the special Law Day program entitled Constitutional Equality for Women in the United States. I am especially pleased to be here because I have a vested interest in the topic. This is our 12th annual Leon Jaworski public program to commemorate Law Day, and our 4th year connecting it here at the Woodrow Wilson International Center for Scholars. We are grateful to the Wilson Center as our host and program partner, and couldn't have hoped for a better venue. I'd like to introduce John Milewski. John is managing editor and host of the Wilson Center's award-winning television and radio program, Dialogue at the Wilson Center, and director of communications for the Wilson Center. As a veteran interviewer, moderator for Leon Jaworski series and other public programs of the American Bar Association's Division for Public Education, we are very appreciative that you're here with us today, Mr. Milewski. And so thank you, and let's begin.
Okay, thank you very much. Appreciate it. And it's always a pleasure to work with the American Bar Association. As you mentioned, I've been doing it even before my days here at the Wilson Center, and it's been a long and enjoyable association. Thanks. You always do a terrific job putting on a great program. Let me also officially welcome you to the Woodrow Wilson Center. How many of you have been here before? Okay, so well, that's good. So that's just about everybody, but there are people watching us via the internet, and there will be a later broadcast of these proceedings. So even though you may know this, I'm compelled to say some things about the center. It's the nation's living memorial to its 28th president, Woodrow Wilson. This is a place for deep research, and also a place that tries to build a bridge between the worlds of academia and the worlds of public policy, with the notion that if there's more dialogue and communication between these worlds, we'll have a better outcome in the world of public policy. And if you'd like to know more about us or our programs, visit us on the web at wilsoncenter.org. So you have a program. You have one of these programs which not only provides biographical information on our panelists, but also has some brief readings on the subject matter that I think you'll find very useful. I don't want to encourage you to not pay attention to us and read during the program, but it is something to take a look at a little later. So I won't give you long introductions to our panel because you have the longer versions in your booklets. But what I will do is give you a brief synopsis of who they are from your left to right. And then we'll dig into the subject matter and then eventually come to your questions and comments. So first up is Jo Freeman, a scholar, writer, and attorney. As an activist in the 1960s, she was an early organizer of the women's liberation movement. She was also a Wilson Center Senior Scholar from 2006 to 2012. Also joining us, David Kaivig, a distinguished research professor emeritus at Northern Illinois University. Among his many accomplishments and honors is a term as a resident fellow here at the Wilson Center. And so I need to mention that. Roger Smith joins us. He's the Christopher H. Brown Distinguished Professor of Political Science at the University of Pennsylvania and chair of the Pennsylvania program, or the Penn Program on Democracy, Citizenship, and Constitutionalism. The only one so far to not serve time here at the Wilson Center, but there's still time, Rogers. Julie, that goes for you as well. Julie Suk is a professor at Yeshiva University's Benjamin N. Cardoza School of Law. During the current academic year, she's also serving as a visiting professor at the Harvard Law School. And Linda Dodd is listed in your program, but couldn't be with us today. So before we begin our program, an oversight, and I want to welcome Patricia Lee Rifo, the National Law Day Chair, who also has a few remarks before we begin our discussion. Patricia?
Thank you very much. The American Bar Association Standing Committee on Public Education has been a primary player in helping to plan and organize this program at the Wilson Center, and I, as the National Chair of Law Day, am a member of that committee. We are incredibly pleased to partner with the Wilson Center in conducting the 2013 Leon Jaworski public program. I just want to take a brief moment to acknowledge and remember Leon Jaworski. He, of course, became internationally famous 40 years ago when he was appointed the second Watergate special prosecutor after the Saturday Night Massacre. But 2 years before that, he was president of the American Bar Association. And in that role, he set about establishing what has become the Division on Public Education of the American Bar Association. And a bequest from his estate in 1983 established an endowed fund which supports not only this program, but other ABA annual public programs focused on advancing the understanding of the public of our law and our legal system. We are pleased to have partnered in this program, as we have for many years, with the League of Women Voters, their executive director, Nancy Tate, and the Federation of State Humanities Councils, their president, Esther McIntosh. We thank them very much for their cooperation and for their support. This program has been a part of this year's Law Day observance. As I hope you know, Law Day since 1958 has been the day on which we stop and pause to think about the role of law in our society. And there are programs going on all over the nation today, in courts, in schoolhouses, and all sorts of other places, addressing this year's theme for Law Day, Realizing the Dream, Equality for All. These are programs designed to help, in particular, young people and adults increase their understanding of law's vital role in American society. And we are very pleased to have played a role in sponsoring this program, and I know we are going to enjoy it, so let's get to it.
Thank you, Patricia.
Before we begin with our panel, let's remember that today is Law Day, Realizing the Dream, Equality for All, an opportunity and a challenge. The theme provides us with an opportunity to explore movements for civil and human rights and to trace the effect of those rights in promoting equality under the law. 150 years after Abraham Lincoln issued the Emancipation Proclamation, 165 years after Seneca Falls, 90 years after the first Equal Rights Amendment was introduced in Congress, 50 years after Martin Luther King Jr. delivered his stirring "I Have a Dream" speech on the steps of the Lincoln Memorial, we have yet to fully realize equality for all. In fact, 50 years after June 10th, 50 years is a celebration of the anniversary of the Equal Pay Act, and we have yet to achieve equality of pay. And soon we will be celebrating or recognizing 50 years after the legislation, the Civil Rights Act, right? And yet we still don't have civil rights for all in this country. Yes, of course, much progress has been made, but much remains to be done. Women and minorities are grossly underrepresented in positions of real power, influence, and leadership. Women are paid on average less than men for comparable work. Although slavery is thought to be a thing of the past in this country, human trafficking, modern slavery, has held in captive over 100,000 U.S. citizens in this country. As we reflect on this year's Law Day theme, let us commit ourselves to the great task of working together to ensure that every man and woman, regardless of race or creed, is able to realize what can be more than a dream of equality. And that is our challenge. So I'm delighted today to be here with you on this year's Leon Jaworski Public Program, commemorating Law Day 2013 and discussing the realization of constitutional equality for women in the United States. Mr. Milewski.
Thank you, and thanks to both of you actually for those remarks. It's great at events like this to revisit the founder or the person who's honored by the naming of it, Leon Jaworski, and not forget exactly who he was and what he contributed. And thank you for, Laurel, also for defining the subject for us and defining the challenge that still exists so we don't get complacent about any progress we've made. And along those lines, what I want to begin with is reading from one of the pieces within this book, ERA's Defeat Predictable by Mary Frances Berry, which says this: from the history of earlier controversial amendments before the ERA, a pattern became clear. In order to achieve ratification, there had to be a perception among a majority of voters in most congressional districts and states that a societal problem existed that had not been remedied by the courts, legislatures, or the Congress, and which could be solved only if the Constitution were changed. So I'm wondering if you look at that test for whether or not a constitutional amendment can be successful and you apply that to how we perceive the problem today, where do we stand in this regard? And let's do it in the order of introduction, and then we'll get a little less formal as we proceed.
You mean with regards to the Equal Rights
Yeah,
Amendment?
well, with maybe not the amendment specifically, but what the amendment tried to achieve, the problem that the amendment tried to address.
Okay, I think that we have achieved in this country about 95% of what the amendment would have achieved had it been ratified back in the 70s when it got out of Congress. We've achieved that largely because of, first of all, pressure by the women's movement. Secondly, because society has changed significantly to make the idea of equality between the sexes a reasonable idea, which it wasn't 100 years ago. And thirdly, because I think our judiciary has simply approached these issues with less of a bias than it did 100 years ago. That doesn't mean there aren't problems left. There are. But I do think we've achieved about 95% of what the Equal Rights Amendment would have achieved had it been ratified back in the 70s.
And just so I'm clear on what you're saying, Joe, is that 95% of what the amendment would have achieved, not necessarily 95% of equality.
No, right.
In the
Well,
bigger
we're only
picture.
talking about constitutional rights.
Right. I know. I think that's clear, but I just wanted to highlight that.
No, we have to be very clear. The
Because we
ERA
wouldn't have a lot to talk about if we had actually been at 95.
The ERA was only aimed at legal equality.
Yes.
Not social equality, political equality, or financial equality. We'd still have all those things to do.
And we might even be able to make a distinction between legal and constitutional equality
Yes.
as well.
We could do that too. Yes.
Yeah, David.
Well, I have to disagree to a certain extent with my friend Joe Freeman. The Constitution has a unique place in our national psyche. It is the fundamental document of our political organization, our governmental organization. The sixth section of the Constitution defines it as the supreme law of the land. And certainly there are many things that it doesn't cover. But especially when an effort is made to amend the Constitution and that fails, we are left with the residue of that failure, and that, it seems to me, speaks volumes to the fact that we have not yet fully embraced female equality.
Interesting. The residue of failure. We'll come back to that, but not right now. That definitely deserves a deeper consideration. Rogers.
I think if we ask simply what would have resulted from judicial enforcement of an ERA, Joe's right, we probably have 95% of that. But if we understand the ERA as something that would have expressed a constitutional aspiration to achieve really equal citizenship in the United States, defined by Justice Ginsburg as equal opportunity for women and men to aspire, to achieve, to participate and contribute in society according to their individual talents and abilities. We're a long way from achieving that kind of full civic equality, which I think is and should be a constitutional aspiration. We still have women severely underrepresented in political office and in many other positions of top leadership, not the ABA, but others. And we also have institutions, policies, and practices that still assign disproportionate responsibility for child care, home care, and elderly care to women, and these practices pose obstacles to really achieving full constitutional equality and civic equality.
Julie.
So I think that the ERA guaranteed or aspired to guarantee formal equality, and I agree with Joe that formal equality has been achieved. I think there was some disagreement and perhaps confusion about the relationship of formal equality to substantive equality at the time.
Can I ask you to define exactly what you mean by formal equality versus substantive?
Sure. So by formal equality, I mean that nobody is discriminated against on account of sex. So essentially, state actors or employers are treating everyone the same, regardless of their sex. And perhaps there was some belief that if we got rid of what I'll call old-fashioned discrimination, women being treated worse on account of sex, then women would then achieve substantive equality, would end up making the same amount as men, would end up having the same proportion of positions of power. And that is not something that happened. And I think there's a confusion as to whether that's happened because we haven't perfected formal equality or because we didn't give enough thought to the material conditions necessary to achieve equality in a substantive sense. And furthermore, I think there are some real problems that arise because to the extent that today many people believe that the sources of inequality have to do with the sexual division of labor, that is, the male breadwinner, female caregiver model, that's something that formal equality doesn't really do a good job of addressing. That is, to the extent that, and in my research, I look at a lot of European countries that actually have departed from a model of formal equality. I mean, there are tensions because there's a model of formal equality that operates with special protections for women. But there are real questions as to whether or not having special protections for pregnancy or maternity leave, that's more generous than paternity leave, whether those kinds of initiatives, which would violate a formal conception of equality, would be helpful for women achieving equality of the sort that Rogers is talking about.
For me, and I'm guessing maybe for others, what you just said raises the question about where even this notion of equality comes from.
Yes.
Is this a cultural idea or societal idea, or is this something that is achieved technically through law and through legislation? Maybe we could start there. What are we talking about when we identify equality as a value or a goal?
Well, first of all, equality is a very old traditional American value. As I have looked at legal history in the last 150 years, there have been two competing paradigms for women, for the status of women. The first of these paradigms is the paradigm of protection. The second was the paradigm of equality. Now, by paradigm, I mean an overarching idea, a goal, a framework. I don't mean absolute achievement. But beginning sometime in the 19th century, the idea was to protect women. This was manifested primarily through protective labor laws, which kept women out of many occupations and limited their hours. But it manifested itself in other ways. The ERA was written to provide a completely contrary paradigm. But at the time it was introduced into Congress in 1923, the dominant paradigm was that women needed to be protected. And because of that, the ERA didn't do too well initially.
Protected from discrimination?
No, not protected from discrimination.
Protected from what?
Protected from exploitation by industry. That was the protective labor laws. Protected from the adversities of the world. Mm-hmm. That women were perceived as being not capable of completely taking care of themselves, and they needed help to protect themselves from all the people who wanted to take advantage of them. That was the paradigm of protection. Now, the paradigm of protection was applied in other arenas to other things. It wasn't unique to women. But as far as the law is concerned, it was the dominant idea. The law needed to protect women. The paradigm of equality, which is a very old idea dating back to our revolution, had been sort of subsumed and recessed during the 19th and early 20th centuries. It reemerged after World War II, and it reemerged largely as a result of the civil rights movement and its constant pounding on the importance of legal equality and equality in all aspects, not just legal equality. The current feminist movement, the women's liberation movement, is the child of the civil rights movement. It inherited its ideas, it inherited its attitudes, and it provided the new approach. It gave impetus to the paradigm of equality. At the time that the Equal Rights Amendment was finally passed by Congress, it was voted on originally in 1946, 50, and 53, but it was finally passed Congress in 1972, there wasn't much opposition to it. It passed overwhelmingly. It was a bipartisan vote. You will not find a split between Democrats and Republicans on the Equal Rights Amendment.
Remember when we had those?
Yes, yes, yes. It was not controversial. It only became controversial later. So where does the idea of equality come from? Originally, the revolution, currently from the civil rights movement.
And then as far as achieving it then, does it come from cultural attitudes, then the law follows, or does the law lead? How do we get to it as a goal?
Well, I'd say the answer to that is yes. That is to say, there is inevitably a process. Laws don't occur unless people are motivated to form coalitions to gain governing power and change the law. At the same time, laws then reshape our understandings. And this is a good example because, as Joe indicated, there have been competing conceptions of equality in U.S. history. As part of the struggle for an ending of various kinds of second-class citizenship for all African Americans, for women, we advanced a notion of equality, you can call it formal equality, that suggests equality means absolute uniformity, same bundle of rights and duties for all. But we have come, since the triumphs of the 1960s, to realize that equality as absolutely equal, identical treatment of all means that many people who are in different circumstances, have different needs, different histories, and different aspirations. They're not necessarily going to get substantive equality by treating absolute.
So what you're saying is technical equality could be a bad deal?
I'm saying equality as uniformity could be a bad deal, but that's only one conception of equality. There's also equality that accommodates differences in ways that produce meaningfully equal opportunities for people. And we have moved into a period where we need to, I think, pursue that kind of equality, and that will mean looking at our laws, institutions, and policies and see if they really work in practice to provide equal opportunities.
Go ahead, David. I'm sorry.
I would say that the history of women's rights has put these two views in tension for a lot longer than has been acknowledged here. The drive for women's suffrage was a complicated business that ended up with a constitutional amendment, but the issues of women's equality and women's protectionism divided the suffrage movement, and the suffrage movement in the late 19th, early 20th century had to confront the fact that if women's suffrage was to be achieved in the Constitution, it basically had to convince men to vote for women's suffrage. It was the men who had to be convinced, and the drive for women's equality didn't go very far with the achievement of suffrage because it was achieved at the expense of telling men that they really didn't have to worry about an upheaval in social relationships by granting women the vote. There were some women, and I think the name Alice Paul is probably familiar to most.
Of the University of Pennsylvania, I want
indeed, a PhD in 1912 from the University of Pennsylvania. Alice Paul was the advocate of a fuller equality than just suffrage. And so she's pushing by 1923 for another constitutional amendment, the Equal Rights Amendment. And she has a much more, shall we say, progressive view of women's rights than did the men who voted for the women's suffrage amendment, along with women in the states where it had been achieved on a state-by-state basis. I think we have to understand that even in the 1970s, the view of Alice Paul is a far more progressive view than American society had achieved, and consequently we see the failure of the Equal Rights Amendment to be ratified. But at the same time, we have to remember that 35 states ratified the Equal Rights Amendment. It is the amendment to the American Constitution that came the closest to being ratified, with the sole exception of the First Amendment that James Madison proposed to the first Congress, which came within one state of being ratified, but has not yet achieved its goal of changing the relationship between constituents and constituencies. Madison's idea was to keep a lid on the size of congressional districts, and if his amendment had been approved, we would currently have congressional districts of 200,000 instead of 700,000, and that came within one vote of approval.
More members of Congress. Interesting. Julie, tell us about, maybe we could learn from where other countries have done better. And again, that depends on what metric you're using, how you're measuring this notion of equality. But in a lot of measures, we see lots of other countries, Scandinavian countries come to mind, that do better as far as things like the income gap. What are they doing differently that has allowed them to achieve more progress in these areas?
So I think that is a very complicated question, and we could start by thinking about the model of equality that we've inherited from the civil rights movement. The American civil rights movement viewed law as a solution to a problem that was also created by law. That is, the problem was that the law mandated segregation and in some situations required racial discrimination. And so the law also, in the many statutes that were challenged on equal protection grounds by feminists in the 1970s, the law made distinctions on the basis of sex. And so the vision of equality that you're getting is not simply no more discrimination, but also that equality is something that is hampered by state action, that the state acts in a discriminatory fashion. And so the strategy of equality becomes one of dismantling the state and weakening the state. And I think that is a vision of equality that is somewhat different from what you see in other countries. In many other constitutional traditions, there's some understanding that the state has a duty to promote equality. And I'll give one example. So the Scandinavian countries, it's not so much coming from the constitutional traditions as I think social movements that led to social changes in the 60s and 70s that really promoted this notion that all individuals should lead autonomous lives unhampered by gender roles. But in some ways, that was not seen to be conflicting with some degree of special protection for women in countries like Sweden. In continental European countries like France, there was a very interesting development by which the protection of women that predated feminist visions of equality were just sort of stayed on the books. And so the protections for women started to have a different understanding in the 1970s when it converged with feminism, which is to say that there's an understanding in the European directives on the protection of pregnant women that you need to do this so that women, not because women can't take care of themselves, which was the older understanding, but a new understanding that these protections do important work in helping women achieve equality in the workplace.
What I seem to be hearing in one way or another from all of you is that maybe the issue isn't our laws or our Constitution, that it's our cultural attitudes.
Mm-hmm. Ultimately, it is.
You're saying yes, you're saying no.
Again, I think
that's good because we like a little conflict, right? So, but we'll each go ahead, Rogers.
The laws don't emerge from nowhere. So yes, you can trace relationship to cultural attitudes, but
they don't emerge from nowhere, but they also speak often to ideals that it's very difficult for us to live up to.
They, again, express aspirations that are hard for us to realize in many ways, true. But they also structure our institutions and practices. They set up certain structures of work, certain systems of public provision. In many of the countries that have made some greater progress toward I think, meaningful gender equality than we have. They're more in the ways of provision of daycare. There's more in the ways of provision of parental leave. There's more in the ways of structuring the political process in order to promote representation of women. These are all laws that actively structure the economic, social, and political practices in ways that generate greater equality and that have an effect over time of leading to greater embrace of gender equality.
So accentuating or enabling the positive versus simply punishing or prohibiting the negative.
Exactly. And I would add, I think it's true that the greatest obstacle to gender equality is that men are reluctant to give up many of their privileges, but they also feel threatened by the idea that if they had greater responsibilities outside of paid work, they'd fall behind in their careers. If you begin to change the structure of incentives in various ways, and public policies play a role in that, you'll get men to change in many cases, their notions of what they want, and they'll be much happier to get the satisfactions of combining, care for their children with success in their career.
Joe, what was your thought on that?
Well, ultimately they are cultural attitudes, but that doesn't mean that cultural attitudes are the only factor that's available. The law can push cultural attitudes, and the law can reflect cultural attitudes. It does both of those. When the law is completely out of sync with cultural attitudes, it gets interpreted to not have the effect that people intended it to have. We can learn a lot by looking at the state equal rights amendments. We're talking about a federal amendment. Well, roughly 1/3 of the states passed state ERAs. 2 states, Utah and Wyoming, actually included provisions similar to the 14th Amendment in their constitutions when they became states in the 1890s. Most of the state ERAs were passed in the early 1970s. A couple state Supreme Courts have read legal equality into their constitutions, even though the language didn't explicitly say that. What do you find when you look at the decisions of states on state law with state ERAs is that it's all over the place. The mere existence of an ERA does not predict the outcome of a case. What does predict the outcome of a case over time? Well, most courts tend to follow the lead of the Supreme Court and its latest interpretation. And the Supreme Court did successfully, over a period of years, tighten the reasons it would allow a discriminatory law to exist. And as it did so, so did the states. That's one factor. Another factor is how many women are in the judiciary. You can provide a statistical relationship between the sheer number of women in the judiciary and the kinds of decisions state courts ultimately make on a variety of discriminatory laws. A third happens to be a liberal conservative dimension. There are all sorts of things that will help you predict what the outcome of a case will be. Very similar cases on similar fact patterns with states with ERAs based upon things that have absolutely nothing to do with whether or not there's a state ERA. So yes, cultural attitudes are important. The law will shape and structure it. I certainly would never say the law was not important. It is obviously important. But it is not important independently of what's going on in the general culture.
Nothing existing in a vacuum here. One of the readings in the program, Robin West, under the heading Extending Anti-Discrimination Principle to Sex, it says race and gender have become analogous to the courts, justifying extension of anti-discrimination principles to sex, and then raises the question, is this a good idea? And this leads me to a question about this specifically, but then to give you some room to play as well. When we look at the law as it attempts to address this question of equality, gender equality, this idea, any other ideas that have become part of the standard operating procedure of the courts, which are those that have been most helpful? Which interpretations of the Constitution, which laws, which particular cases do you think have furthered us toward a goal that we could all agree to as a positive outcome? And which, in this world of unintended consequences that you've touched on, have been problematic and have maybe kept us farther away from the goal than where we want to be today? Who'd like to begin? I know it's a big question, lots to think about. I can do a stall if necessary while you take mental notes. Now this musical number in honor of Law Day.
Well, I would argue that the failure of ERA to be ratified has cast a shadow over the issue of women's equality.
You called it a residue of failure earlier. What are you saying, that just the fact of failure creates a perception that it's what, not important enough, or what is the this residue?
That the country has not fully
We're not ready
embraced gender equality. And I think the actual history of the ERA has not been well enough understood to counter that perception. In fact, the Equal Rights Amendment was the victim of two intentional acts by U.S. senators. You may not think of them in terms of the ERA, but Warren Harding and Sam Ervin, I think, are responsible more than any other two senators for the failure of ERA. Warren Harding, of course, was not present for the vote over ERA, but in 1918, he was debating how to deal with the issue of national prohibition. He was a senator from Ohio. Half of his state was very much in the temperance camp, and half of his state liked to drink. For a politician, that was a very uncomfortable position because he was up for re-election. And so his act of genius was to say, well, I don't think enough states are ready to ratify a federal prohibition amendment. So why don't I tell the Anti-Saloon League that I will support their prohibition amendment if we limit the time for ratification. He proposed 5 years. They negotiated. They agreed on 7 years. There had never been a time limit on ratification of a constitutional amendment. But Harding thought, well, with a 7-year time limit, the Dries won't be able to get their amendment ratified, and then we'll be done with it. And my drinking buddies will breathe a sigh of relief. Well, it took the Anti-Saloon League 13 months after Congress approved the Prohibition Amendment to achieve ratification. And we then had national prohibition for more than a decade before another constitutional amendment erased it. Amendments proposed after the 18th, including the 19th, did not have this time limit. There were a few amendments proposed that did have a time limit, but it was not required and it was not common. When the ERA came up in the early 1970s, Sam Ervin, who was steadfast in his opposition to the ERA, complained that there was no time limit proposed. And in order to try and win over his vote, the chair of the Judiciary Subcommittee on the Constitution, Birch Bayh, agreed to put a time limit on the ratification of the ERA. That time limit meant that opponents merely had to delay the ratification process in enough states to prevent ratification. And my argument is that without that time limit, the ERA would have eventually been ratified, and we might be having a discussion today about some other subject.
Sounds like the team says if the game went on a little longer, we would have won. We would have come back. But which you're not sure.
I'm not sure. I'll let you guys address
Rogers,
that. I
what do we
mean, we did extend it for 3 years, so we actually had 10 years to do it. I couldn't come down definitively one way or the other.
Yeah.
I'll just say I'm not sure that would have worked. Go ahead.
Let me talk about a couple of post-defeat of ERA developments, though, that respond to your question about, well, what's been good and what's been bad. A couple of decisions that I think are good are Justice Sandra Day O'Connor's opinion in Mississippi University of Women versus Hogan, and then the opinion by Chief Justice Rehnquist in Nevada v. Hibbs. Both these are good, I think, because they paid attention to the actual consequences for equality of opportunity of the ruling. In the O'Connor opinion, she insisted that the nursing schools needed to be open to all, against the argument that, well, women might like schools that are just confined to women as a kind of nurturing atmosphere. But her point was, look, we all know that nursing is a women's profession in this country, and if we really want to open up nursing to a profession that men and women participate in more equally, so that it's not just seen as women's work, we don't want these designated women's colleges in the same way. In other situations, maybe that would help advance women's equality, but not in the situation of nursing. And in Nevada v. Hibbs, the Chief Justice rejected a challenge to the Family Leave Act because he said there is plenty of evidence that the way that family leaves are operating at the state level, it is not really providing meaningfully equal opportunities for men and women to engage in daycare and elderly care. And so we did need policies that would promote more equal sharing of responsibilities. And I think those opinions that look at how we're actually going to affect the practices of gender equality are valuable. On the other side, there's been a series of decisions that say we only focus on intentional gender discrimination. We never pay any attention at all to how the law impacts actual practices in differential ways, harming women and not men. If there's no intentional discrimination, we say there's nothing wrong with it, and often there is a lot wrong with it.
So there are a lot of ideas that have been developed by U.S. courts and the U.S. Supreme Court that have in some ways taken off in other countries but have been more limited here. And disparate impact liability is a very good example of this. So in the Griggs case in 1971, the Supreme Court says for Title VII purposes, a policy, an employment policy that has a disparate impact on any of the protected groups constitutes discrimination. But later, just 5 years later, they declined to adopt that as a constitutional principle. And certainly, there are questions that come up for the courts. For example, if you pay part-time workers less because they're part-time workers, is that a policy that has a disparate impact on women because women are more likely to be part-time workers? In many European courts, the European Court of Justice, it's, the answer to that question is yes. If you discriminate against part-time workers, that's discrimination against women. our courts have been reluctant to make that move for fear of granting judicial cognizance to the notion that women are more likely to be part-time workers because of their child care responsibilities. And it's an example of the very strong individualist framing of equal protection rights in the United States, that anytime you have a generalization about a group, even one that's statistically supported, for example, women tend to do more caregiving, it's something that we're very nervous about allowing to have the backing of the state or even any kind of employment policy because of some notion that individuals who don't conform to generalizations are protected.
Is this you've made this point in written pieces about
Yes.
anti-stereotyping approach has not worked well.
Yeah, and so getting to the Hibbs case, I have to disagree to some degree with Rogers because basically Justice Rehnquist says that the states were discriminating in providing parental leave. And what he means by discriminating is that there were states that provided maternity leave without providing paternity leave. And what that meant was that men were discriminated against because they didn't have an equal opportunity to go on paternity leave. And certainly, to the extent that you want the law to be encouraging people to have a more egalitarian relationship at home, which is very important to the achievement of gender equality, then you want to have laws that provide equal maternity and paternity leaves. But that position would basically preclude, in some ways, he answers a question that was left open by the CalFed case in 1989, which is whether or not a state would be discriminating if it gave more generous maternity leaves than paternity leaves. And I think one consequence, that is, if you have a legal order that says you can't discriminate, but the state is not required to give anybody paid leave, one consequence of that is that the way that you do equality is by giving nothing to everyone. So unpaid leave for everybody, equally to men and women. And I think one consequence of that legal position is that then culture takes over. That is, then if the law is not trying to reshape the relationship in an active way at home, that it does mean that women tend to take more maternity leaves, even though they have the legal right to take unpaid maternity leaves that are equal to their husband's right to take unpaid paternity leaves. And so these are some interesting dynamics that I think that this idea of disestablishing the discrimination, that brings us to a point where then people just do what they're incentivized to do by the market,
So
and
Julie,
that tends to reinforce
who would you say,
gender dynamics.
and this might not be an either-or question, but
Yeah.
let me at least start there. Because what I'm hearing is that we are somewhat in denial of some basic realities of nature when it comes to the differences between men and women, and which is, I'm trying to figure out, is it our culture that's uncomfortable with making those distinctions, or is it our legal system, or is it both?
Okay, so I am not saying that women want to do more caregiving. Basically, there was a gender division of labor on which the old constitutional traditions were based. That's why women couldn't vote, because women's role was not to be in the public sphere. Their role was to be at home, raising the children, and taking care of the home. So the breadwinner-caregiver line is not something that's just cultural. It's constitutionally, it's just a feature of modern constitutions that women are not market participants and they are not citizens. And at some point we decided that that was not the right way to do things. So we went to formal equality. We said women are also citizens. But we actually did not do what it took to rejigger the relationships that the old traditions were premised on. And so now if women are doing more caregiving, it's not because they're naturally inclined to, but we've become path dependent on an old order that had the support of all the major institutions. And so I think right now we're just in this awkward phase where we decided as a formal legal matter that the old institutions did not reflect the way we wanted things to be, but we never actually did everything it took to fill all the gaps left by having everybody be market participants and citizens. Because if everybody's a market participant and a citizen, it's just kind of this unspoken, nobody knows how the children are going to get raised. And so everybody has some solution that looks like it's going to fall apart. They rely on family members who are not paid. or they are wealthy enough to pay somebody to do the caregiving work, right? But there are all kinds of solutions that are not collective in nature, and there's no collective solution.
Okay. I think you need to have a much broader view of social change. I don't disagree with you, but I think there's an assumption in there that things can change completely all at once. Maybe that's not what you meant, but that's what I heard. When I was growing up in the 1950s, the normal expectation was that a woman got married and raised the children. And if she went to work, it was before she got married. And if she worked at all after she was married, it was unfortunate. Okay? It meant the family was not doing too well.
You described that as if that attitude doesn't exist today.
Well, let me finish. I'm not finished. Okay?
It's past tense. No?
Well,
I've experienced it last week.
It was unfortunate if a woman had to work outside the home and wasn't there raising her kids. The revolution of my time, of my generation, was to say that it's perfectly okay for a woman to work as much as a man, to have the same career as a man and earn the same money as a man. That doesn't mean she actually gets it, but that it's okay to do that. That was a major revolution. Those of you who haven't lived through it should not forget how major it was. The next revolution, the one for my grandchildren, if I had any, is to make it equally okay for men to stay home with the kids and to do a full and equal share of house care, child care, home care, and all those things. That revolution hasn't happened yet. Okay? We're waiting for that one. I think it will happen. We're moving there, but that's the next revolution. Now, we could go back even further than that. There was a time before my generation in the 50s in which it wasn't okay for a woman to work at all, let alone the little bit that they could do when I was growing up. So there's this long process of slowly moving women out of the exclusive responsibility for home care and child care into sharing the opportunities of the world and work. And there's a parallel but lagging process of making it okay for men to work in the home.
And for those of you alarmed by this next revolution, who are either in the room or watching via television or the internet, there's good news. You may die before it happens. So.
It is important to note here, though, that many women have always worked outside the home, especially African American women, often as domestic workers, and working class women, often doing factory work. There was a kind of white middle class ideal. It was certainly true in my family that the women weren't supposed to work. It's never described American practice, and indeed we had laws and policies that pushed a lot of women to work by necessity and to do child care. And the kinds of transformation that I agree with Joe completely that we need now, it's happening to some degree, but the reason I had reservations about focusing on cultural attitudes earlier alone is that people hear cultural attitudes have to change and they sort of conclude, okay, so we don't need to do anything. We just need to wait for cultural attitudes to change. I know that's not what you meant, but I worry that people will see it that way. Instead, we do need public policies that promote change. Public policies help promote the old patterns that we got. And so the state does need to play a role in change, as Julie was saying, and I don't disagree with you that the line in Rehnquist's reasoning that points to formal equality is not sufficient. What I do like about the Hibbs case was precisely, though, that in its context, it did encourage an expansion of opportunities for men to do some domestic care and help legitimate it, and it's that kind of legitimation we need.
So, Rogers, then see if you can answer this. This is tough, but where does that pushing and prodding come from? Because our discussion has revealed today that there are limits to the law as it relates to culture, and there are limits to culture as it relates to law. There are limits imposed on this equation based on nature. Just the carrying a fetus to term, to childhood, creates a circumstance for a woman that doesn't exist for a man. But avoiding your challenge of avoiding complacency and not just saying, well, you see, we have all these limitations. Where does the pushing and prodding come from? Do we need a new ERA movement? Do we need another run at a constitutional amendment? What needs to happen?
I do think we need mobilization for policy change.
Grassroots mobilization?
Grassroots mobilization, but that feeds into forming advocacy groups that affect political parties and legislative policies. I'm not sure that the target now should be a new constitutional amendment, because I think the changes that we need are mostly in public policies. And even if you had a constitutional amendment, the very difficult question of what the right public policies are to encourage change would not be answered by that amendment. So I think we need to work more through legislative processes. But unfortunately, because we do have substantial measure of formal equality, a lot of people want to say gender equality is solved, and we're not focusing on these entrenched patterns of gender inequality. We need to mobilize to address those.
Before we get other comments, just I want to make the vote on whether or not we need a new ERA. Rogers thinks no. Julie?
So I think we need something, but I don't know if it's a new ERA.
Okay, so not a constitutional amendment necessarily.
Well, possibly a constitutional amendment, but not
a rewritten version, something different.
Yeah, and I could talk a little bit about what I have in mind.
Sure, go ahead. Go ahead.
So I think the real problem with the ERA is similar to the problems that we've seen in the development of equal protection jurisprudence, both in the race and sex context in the United States, which is that over the last few years, there has been a narrowing of an understanding of what Congress can do to enforce the Equal Protection Clause. And we've always understood sex equality and race equality in symmetrical terms. And what that means is that discrimination against blacks is the same on moral footing, is on the same moral footing as discrimination against whites. And so what that means is that at this point, affirmative action, the idea of race-based affirmative action, or any kind of positive action to protect groups or to promote the equal opportunity of previously excluded groups, comes into question based on the symmetrical framing of equal protection. And it's a symmetrical framing that I think was in the Equal Rights Act. So, and I think that now, if you look at the European countries that have passed constitutional amendments in the gender equality area, France and Italy are examples. They've passed constitutional amendments because in the past there was legislation to require gender quotas in the context of electoral positions. There was legislation to have gender quotas for legislatures, and more recently gender quotas on corporate boards of directors. And initially the constitutional courts in these countries said that these violated the equality provisions of their constitutions, and it was in response to those rulings that there were constitutional amendments explicitly saying that the law shall promote equal access by men and women to positions of power. Initially, over a decade ago in France, it was an amendment that said equal access by men and women to elected positions, and more recently in 2011, equal access by men and women to positions of professional and social responsibility. And if you note, the rights language is not there. It's equal access by men and women, and so it suggests the possibility of having rules that might sometimes treat women better or differently because you do what it takes to create equal access. And I think these are the kinds of things that in the evolution of our equal protection jurisprudence, and we could imagine that if we had an ERA, that jurisprudence would have evolved similarly. The things that are going on in Europe are actually very much in tension with the equal protection law that we have in the United States.
Okay. David, do we need another round of the ERA or something else?
I think we do need the ERA, and the beauty of it is the simplicity of the language, and I think we would see somewhat different court opinions in the last 35 years. Had we had the ERA in place that was hoped for by the late 1970s.
Could you identify one specific example in that regard that you think might have been ruled on differently had the ERA? And I'm sorry to put you on the spot like that. I'm just wondering, it would be just useful to understand.
Well, I'm the only non-lawyer on the panel, so my
political scientists can practice law here on Law Day.
No,
we all get
But not legally.
Yeah, not legally, and I'm not a political scientist either. I'm just a
historians,
poor, broken down historian. The one thing that I would say is encouraging about the prospects for a new ERA is that I think culturally we have proceeded beyond where we stood in the 1970s. The opposition to the ERA was focused in the 1970s in the states of the Old South and the Mountain West. And we've seen in those cases cultural developments that I think are encouraging for the standing of women in the United States. The second big mistake in ERA, besides accepting the 7-year time limit, which proved fatal, was that the historical example of the repeal of national prohibition was not heeded. That is the only amendment that we've had to the Constitution since the Civil War where the alternative system of ratification that was provided in Article 5 of the Constitution was employed. Instead of having state legislatures ratify the 21st Amendment ending prohibition, the advocates of repeal insisted that conventions be held in the states and that there would be a popular election of delegates to the convention. People would vote for a delegate who had either announced that he was for prohibition repeal or against it. And what we got was a national referendum on a constitutional amendment. Had that system been used in the 1970s with ERA, I think we might have gotten a different result than the result we got from state legislatures that were very susceptible to special interest lobbying. If we had a new ERA passed by Congress, I know that's a big if at this point, a reference to state conventions would, I think, reflect the cultural changes that we've all been talking about here, and an ERA would have a much better chance of approval.
Joe, if you were a young activist taking to the streets, would it be dusting off the ERA and trying again, or a new approach?
I would not be dusting off the ERA and trying again.
Okay.
If you want to hand me the ERA on a silver platter, I'll take it. It'll do some good. But if you want me to invest time and energy in bringing about major social change, the list of things that you identified would be much higher on my priority list than getting a constitutional amendment at this point. And I could add a few more. And that revolution I talked about men taking more responsibility for home care and child care, that's not going to happen with an ERA. I'm not even sure you can do that with public policy. Maybe you can. We can argue about that, but I'm not all that sure about it. That requires major changes in social attitudes, and major changes in social attitudes requires grassroots activism. So if I were a young activist today, I'd be working on the list of problems you outlined and a few others that you didn't go into. I wouldn't be working to get another Equal Rights Amendment.
Okay. Did you want to say something? I saw you lean forward. I thought it was a nonverbal cue.
I think that, I mean, just to give an example of public policy, so in Sweden, with regard to fathers, what they do is they create paid parental leave that's available to the two parents. And the more they share it, the more time they get. And so if only one parent takes it, then it's a few months shorter than if both parents take it. And of course there is, I mean, so I'm talking in very neutral terms, but the extra days, which I think are 60 days, are called the daddy days because those are the days you lose if the family doesn't take it. But if the daddy takes at least 60 days, then the child gets more time at home with the parents after the child is born. And so that's an example of one initiative that's incentive-based that would encourage, and it is encouraging fathers to take paternity leave, surprisingly or unsurprisingly, the take-up rate is not 100%. That is, there are Swedish dads who just don't take any of that time at all. There's paid paternity leave in almost every European country. It's shorter than paid maternity leave, but it's also interesting to note that it's not the take-up rate on the paid 2-week paternity leave is not 100%. There are men who don't take any of it, even though they would be paid to take it.
So when America preaches family values, it needs to put its money and its legislation where its mouth is.
Exactly.
That is the challenge. We want to come to your questions and comments and include them into this discussion now. And so we'll have a couple people here helping you with microphones. So please indicate if you'd like to ask a question. There's a woman right here. If you'd get that microphone to her, we'll begin with her. And Eric, you find somebody who's in line on the other side, and we'll go back and forth. Ma'am, if you would stand up and ask your question, it's just easier for us to introduce yourself.
I'm just curious. Sorry, my name is Laura Williamson. I'm curious about in Sweden, what if it's a single parent household?
You thinking of moving to Sweden? You want to know what the deal is here?
No, I'm just curious how they handle that. So if you get extra days for daddy, but it's a household that only has mommy, are you just sort of, short shrifted on that, or?
So I don't know what the provision on it is because I know it's an allocation per child. So they've probably got something to deal with that situation. But you are right that it does raise the question, though, that in a lot of continental European systems, there is an understanding that there are two parents, the mother and the father. And this has become a heated issue with regard to the gay marriage debates in France right now, because the main opposition to gay marriage comes from people who say every child has a right to have a mother and a father. And it does proliferate this view that if you come from, if you don't have one of those, then somehow your life has been less than complete, right? And this is something that I focus a lot on in my work, that I think in a lot of these European systems that have very generous maternity and or paternity leaves, the state is taking a position. The state is saying it's worthwhile to be a parent. It's more worthwhile to be a parent than to do other things. The state is not letting people decide for themselves. And an example of this is that under the European Directive on the Protection of Pregnant Women, every EU country has to have at least 2 weeks of maternity leave that's mandatory. Mandatory meaning not only that the employer has to give it to you, but that the employer will be subject to criminal or administrative sanctions if they let you show up during the 2-week period when you should be on maternity leave. And some countries, including France, make the mandatory period longer than 2 weeks. So there's an 8-week period. And what that means is that the woman's right to choose to work has been abridged. And they do it because they're afraid that there will be pressures for people to take ever shorter leaves. And those are pressures that exist in our economy, that people will think that they have to take shorter leaves unless there's a mandatory dimension. And one serious discussion that's going on right now is whether or not paternity leave should be made mandatory as well. That is, have the employer be subject to criminal or administrative sanctions for allowing new dads to work when they should be on paternity leave.
I just hope there's someone from Wilson Center HR in the room while you're describing these rules. Yes, sir, you have a question? Back there, Eric, in the back of the room.
Thank you. My name is Chris Bennett, and I'd like to take a little more of a clinical perspective. Is there any information or data on a nation state or a culture that started from a base of equality and a look at how well it's done compared to ours and other countries that start from more of a patriarchal perspective? And one thing that comes to mind, I think, in ancient Sparta, supposedly, the women actually were a very key part of the overall economy and the overall culture, and that might be one data point, for example.
You've taken our history lesson back farther than it has previously gone.
I don't think Sparta is a great example of gender equality. However, just the structure of governance didn't allow women to govern, and the solicitude for choices of family.
Mandatory paternity leave for Spartacus.
Right. But your question raises a fundamental reality. We can't point to any major society historically that embodied gender equality. The reality is that our contemporary societies have emerged out of long traditions of patriarchy and often domination and exploitation of women by men. It varies in different ways in different locations, but there's no great egalitarian example to go back to. Now, unless you think that the way everything was done 2,000 years ago is prescriptive for the way we should do everything today, you don't take the fact that we haven't had gender equality in the past as an argument that we shouldn't try to achieve it in the future. But it is an indication of how there are deeply entrenched practices and patterns of social structuring that aren't going to be easy to change. And again, that's why I think complacency is a greater fear than anything else, precisely because the tasks are so challenging.
I'm no expert on Greece either, but many years ago I read a book on slavery in ancient Greece. And there is one fact that stood out in my mind that I still remember to this day. In ancient Greece, most slaves were women. Most women were slaves. There is no model of equality, of gender equality in ancient Greece, not by a long shot. You might want to read some of Margaret Mead's work that she did in a variety of non-Western worlds in the 1930s, particularly her book Male and Female. One of the things that she said was that in different tribes, men and women do sometimes perform very different tasks. So that a task that would be done by a man in one tribe might be done by a woman in another tribe. But the one constant she found was that in every tribe, the work that was done by men was more important. Translate that into our modern world. When 90% of doctors were men, being a physician was an exceedingly important profession. In Russia, or Soviet Union, where 90% were women, it was a very minor profession. So
very interesting. Before we take the next question, I want to introduce a special guest who's able to join us, coming from another appointment, and she brings to the table many perspectives on this topic, technically as a member of Congress, as an attorney, but also as a woman. First-hand experience is what it takes to try to break through some glass ceilings and achieve things in a men's world. She is the Director, CEO, and President of the Wilson Center, and happens to be the first female to hold that role. I'm going to ask to come to the podium now the Honorable Jane Harmon. Jane, thanks for joining us. And I don't know if you're at an advantage or a disadvantage for not having heard some of the preceding
Well, I certainly support the ERA, and I was there as a congressional aide when it passed, when it finally passed the Senate in the early 70s, and I watched with gloom as we didn't get enough states to ratify it. But thank you, John, and hi, everyone. This is the third ABA Law Day event here that I have been able to stop by to greet. There was one shortly after I joined the Wilson Center in 2011, and then one last year, and now this. But this one has special meaning to me for a number of reasons, and I just thought I'd put them out there. And I know it means a lot to all of you, too. But one, I was there when the Senate ratified the ERA, and it was depressing, as I said. Two, during the early 70s, as an aide to a U.S. senator, I was counsel to a judiciary subcommittee on access to justice. And I worked very closely with the ABA at the time, and with Chesterfield Smith, the legendary president of the ABA, who was truly amazing. And our goal was to figure out ways to have, not just through legal services programs, but other ways to make justice more accessible to everyone. And thanks to a lot of people other than me, I think that has been improving, at least in the United States over the years. Surely not perfect, but the ABA has a fond place in my heart for reasons like that. I then was elected to Congress, as some of you know, in 1992, the so-called Year of the Woman. It was the Year of the Woman. It didn't augur in what we all hoped for. It was called that because the number of women in the House doubled, and several states, including mine, California, elected 2 senators who happened to be women, which is wonderful, and they're still there. And in 1994, sadly, a number of the women elected 2 open seats, as I was, lost re-election, and that was a total downer. But in 1995, I went to the 4th UN Conference on Women in Beijing as part of a small congressional delegation. And so I actually was there when Hillary Clinton said women's rights are human rights and human rights are women's rights. It was the iconic phrase, it still is, of ever. But that is when I got fully familiar with something that I'm sure you all care about too, which is CEDAW, the Convention on the Elimination of All Forms of Discrimination Against Women. And it is a horrifying fact, in case anyone missed it, I assume many of you do know this, that of the 194 members of the UN, 187 have ratified CEDAW, and you know that one of the outliers is the United States, along with Tonga, Palua, Iran, Somalia, South Sudan, and Sudan. Just get your heads around that. I mean, that's something, in addition to trying to get the ERA ratified, I thought I'd come and give some homework assignments that we ought to work on. It's embarrassing. And we just, at the Wilson Center, we have something called the Global Women's Leadership Initiative, which has a goal of working with the 7 sister women's colleges, and now a growing list of colleges, of helping put women in 50% of public service jobs by 2050, 50 by 50. But we had a conference last week in Tunisia. I was not there, but the head of our program was there, and she said that Tunisia had ratified CEDAW with some reservations, and she was able, with the other women in the room, many of whom are Tunisian, obviously, to get those reservations lifted. So if Tunisia can do it, can't we do it? I mean, that would be just a kind of question. And finally, my other homework assignment for all of you, and at least this expresses my keen view, is I think it's time to close Guantanamo. And doing that politically will be very hard, but I brought today's op-ed in the New York Times, languishing in Gitmo, and the story is just horrific. I mean, half of these people have been cleared for release, but they haven't been released because there are very few options. Most of them are Yemeni. No one wants to take the risk of releasing them and having them go back to lives of terror if they were in fact involved in terror, and trying folks in our federal courts, which is a very good option, has been for the moment blocked by Congress, although the president has a waiver. And so I just wanted to put out there, as someone who cares intensely about the ERA and knows what its impact is, on women's opportunities in this country, that your homework needs to have some more items on it, and maybe it actually does. The Wilson Center cares about this stuff. We really value the rule of law. A point we make all the time is that living our values is the best way to project a U.S. foreign policy, the best way. Kinetics are useful sometimes, but they're not going to win the argument. What wins the argument is the rule of law, and that's what the ABA does. And I've had great affection for it forever. And as a one of the oldies as a woman who was a partner in a law firm and did a lot of those things 1,000 years ago, I just have a great respect for what you do. And let me just close with this. It reminds me when I was graduating Smith College 1,000 years ago, I decided I wanted to be a lawyer. It was not something that many women wanted to do at the time, and I said, I want to be a lawyer and I want to take the law boards. Smith didn't even offer the law boards. I had to go to Amherst, a men's college 7 miles away, to take the law boards. And so and lots of you have climbed very steep mountains in your own careers, and you're prepared to climb steep mountains so that other women have opportunities. And I just salute the ABA and welcome you once again for your annual trek to the Wilson Center. So thank you, John, for letting me interrupt, and welcome.
Welcome interruption, thank you. And not that we can be complacent, but at least we can take some satisfaction that the ABA and the Wilson Center have women presidents. So lots of work to be done, but... Okay, and now if you'd help with the microphone, the woman right to the back of the room was next in line.
Hi, my name is Carolyn Cook. I'm a small business owner, United for Equality, LLC. And David and Rogers, I just want to say that I could hardly contain my excitement just hearing your views on why we still need an ERA. And in 2009, I drafted a proposal urging Congress to remove the deadline for the ERA for the last 3 states. It was introduced in the House in 2011, in the Senate in 2012. It had, and it's about to be reintroduced May 9th by all men. Senator Cardin from Maryland, Senator Kirk from Illinois, and Congressman Rob Andrews in New Jersey. So I just want to say that I think in the same history of how slavery needed white people to come over to its side, I really want to applaud you and the men that are standing up, whether women realize we need equality or not, and taking a stand and saying it's time. And I just would like to make just a few comments on some of the things that you said. I'll just try to run through it quickly.
Very, very briefly,
yes.
Please.
When we talk about laws being 95% of the way achieved, there is no catalyst to remove bad laws that are on the books. In 2011, New Jersey had a law that stated that a woman could not testify against her husband in court. It turns out that a man had murdered someone and the star witness was his wife. And they sat there biting their nails going, oh my gosh, what are we gonna do? Well, the husband ended up pleading guilty, so they didn't have to deal with it. But the only reason why these laws started to come up was because a Democrat and a Republican, both women in New Jersey, started to go through the laws on the books. So without an ERA, we don't have a catalyst or an impetus to require the 50 states to systemically go through and look at all the laws that have been created since, for 224 years that began with women are the property of their husbands, and make sure that none of those.
What I want to do, I want to give the panel a chance to comment on that point you just made, because it's an interesting point about the ERA could serve as a catalyst to review these various. What do you think of that thought? We've gone back and forth on whether we need a new ERA, a revised ERA, something different. What about the point that was just made? Can you see it operating in that? Well, you were the one who voted enthusiastically for bringing back the ERA.
I certainly applaud those sentiments.
And I
hang on a second.
I'm just puzzled because it seems that it would probably violate equal protection. So I guess I'm puzzled as to why you think that the ERA would catalyze a comprehensive review of such laws. I mean, I think it is true that in our legal system there are a lot of bad laws that don't get challenged until there's an active case or controversy. And so, but what it means is that eventually, if anyone tries to apply it, it probably will. There will be an equal protection challenge, and it would probably be invalidated. And so, I guess I am curious to know. And maybe you're talking about the possibility that if we had to think about the ERA, the states would actually proactively start thinking about everything they have on the books that would violate the ERA in a way that we do not about the laws.
That's the way I interpret it. Was that the point?
Well, or they would be violating federal law, because whether we have state ERA constitutions, most law students are schooled in federal law, not state law. So that's what they use to argue cases. So it's really pretty irrelevant that 23
Okay, you know, you
states.
said you had a list of points. Make one more, and then I'm going to move on, just in the interest of time. And I hate to do that to you, but time is a limitation.
Okay. I guess what I would like to say that I think that the structural flaw that we have in this country is that women are second-class citizens. And what that has resulted in is the outsourcing of women's needs and women's issues to nonprofits. And where nonprofits are held back is that they handle the direct service, the immediate needs of what women and children need. And they are predominantly, the nonprofits are geared for women and children. But what they can't do by law and by ERS threat that they'll take away their nonprofit charitable status is they can't lobby effectively for public policies. Second-class citizens cannot petition their government in the same way that a citizen with full rights can do. And so that's where I think, as a work-life practitioner formally for an award-winning company, what I saw was a problem was that our government has not gotten involved, and you both spoke to this point, of really bringing our workplaces and our national policies up to speed now that we have a dual-earning workforce. And so that's where I think the ERA will have.
Thank you. Thank you. Would anyone like to comment before we go to our next question? There's lots to comment on, but no, we'll let the comments stand on their own. Okay, who is next? Right here, this woman to the middle. Thank you.
Hi, my name's Lu Chang, and I'm a student at Dartmouth College, and I actually just took a class on CEDAW, so I was very excited to have that brought up. And I was curious as to what the panel thought about a lot of the arguments, both in regards to the pro and the con side. In class, we discussed a lot that it seems that both sides say that, well, it really won't make a difference whether or not we pass it. And one of the
Talking about equal rights amendments specifically.
actually
Or
about CEDAW, and
okay,
then
CEDAW.
by extension the ERA as well. And one of the sticking points that did seem to matter was the idea of the U.S. having to report to the international panel. That seemed to be somewhat arbitrarily selected, and then just having to subject American cultures, I suppose, to international scrutiny. So I was wondering what you guys thought about the viability of passing CEDAW and whether or not it would really have a positive effect or an effect at all.
Well, I would say you can't be certain that simply ratification of any international agreement is going to have a huge transformative effect on American society. But it's also true that the refusal to do so sends a symbolic message that this country is not really strongly committed to gender equality, to advancing the interests of women. And the concern that we might have to appeal to an international tribunal, well, there has been an effort to shelter American practices of racial, gender, and labor inequality from international scrutiny through much of our history. It's hard for me to see that that's proven beneficial to achieving the objectives of equal citizenship we profess to pursue. We're in a 21st century world in which global interconnections mean that progress on many issues have to come through international multilateral actions, and gender equality is part of it. So even if the treaty wouldn't do everything simply by itself, not to ratify it is a statement that we really don't want to change very much. Not a statement we should make.
Yes, sir, right here. Hi.
Hi, Bob.
Your microphone, please. He's right behind you.
Thanks.
There we go.
Evening. I'm Bob Weinberg, a member of the Individual Rights section of the American Bar Association. And I'd like to revert to the question of whether there has been a society based on gender equality. And I think we do have an example of that in the kibbutz in Israel, previously in British-mandated Palestine. The society was based on agricultural communities with needs for collective cooperative farming and cooperative defense. And a key institution of the kibbutz was the children's home. The children were not raised by the mother. The mother was not the principal caregiver. The children lived, for the most part, in a children's house. There was collective responsibility for the children. They would spend time with their parents, but generally they spent overnight and preschool during the days in the children's home. And this produced a society which was very successful at what it was doing and developed great national leadership, brought about an independent state. And these were secular, socialist inhabitants for the most part of the kibbutzim. I think books have been written about the children of the kibbutz, what the psychological effects were and the like. And perhaps it's no coincidence that either the first or very nearly the first democracy to have a woman prime minister was Israel's Golda Meir, although she grew up in the United States rather than the children's home. But I'd be interested in the comments of the panel on that as a social model which perhaps can show something about gender equality and what it can yield.
I know less about the kibbutz than I do about ancient Greece. I think I would ask a question to you. How many kibbutzim raising their children collectively still exist?
I'm sorry, couldn't you?
How many kibbutzim raising their children collectively still exist?
Well, I think a lot of the kibbutzim still exist.
You need the microphone, sir. You need the microphone.
With the society becoming an industrial society rather than an agricultural society, and primarily an urban society, the framework for having the kibbutz as a cooperative farming community just isn't there.
So they're not raising their children collectively anymore?
At least most of them aren't. I don't know if some...
Well, I guess my
so unfortunately, the one example we could come up with no longer exists in the same way it did.
It doesn't exist in the same way because the society has changed. But it was a very successful institution within that society.
Okay.
Well, I do think it's a very interesting question to ask whether we ever started, are there any societies that had gender equality? Because I think that the separate spheres tradition, the breadwinner-caregiver model, to modernize, it's the paradigm of gender inequality. But there was a point at which I think it did not register with anyone that that was unequal. And in part, I think perhaps before the Industrial Revolution, it was considered an arrangement that was equally beneficial to all. And I think there came a point at which it became obvious because of social changes that that was not the case. And I mention this now because and it relates to something that Joe said earlier. One discussion that's going on right now is about the extent to which the post-industrial economy favors women and disadvantages men. So because of the decline of manufacturing, male jobs are declining and service sector is increasing, healthcare sector is increasing. So it's only a matter of time, another generation, before women just are more employed and men have to stay home. Well, it is a discussion that's going on. And so now the question is, does that smack us as being gender unequal? Or is it just a new egalitarian framework by which men have now just gotten used to the other side of the separate spheres tradition? And I think it's kind of a deep question for understanding what we really mean when we talk about
Well, and you can
gender
ladle on
equality.
top of that just the changing nature of work and how much of it is needed. Remember books like The End of Work that were written several decades ago that still make sense today when you talk about more and more technological efficiencies eliminating the need for as many workers doing as many tasks for as many hours as would usually constitute the so-called working wage or living wage.
But before we leave the subject of history, I just want to say we shouldn't understand current patterns of gender inequality as resulting simply from industrialism. Blackstone was writing for a largely agrarian and partly commercial England, and he wrote the husband and the wife are one, and that one is the man, and that was the law.
So the Industrial Revolution did not create racial or gender discrimination.
And I would say that the economic transformations today, including the less need for work, are providing opportunities, if we choose to pursue them, for more equitable work-life balance for men and women alike.
Before we close, I would like to offer each of our panelists 20, 30 seconds to share with us. It's a new tradition we started at the Wilson Center because sometimes you just run out of time on a panel and it's somewhat unsatisfying. So the question we've been trying for our panelists is sort of your takeaway from today. In other words, not necessarily the last point you want to make, but something you learned today that you're going to spend a little more time thinking about that perhaps one of the other panelists said, someone in the audience said, but the thing that you're going to leave the stage thinking about today. Let's begin with you, Julie.
So I am very interested in this question of the symbolism of having an ERA. Because it's been my view that I'm not sure that it would do legally what equal protection hasn't. But I think the idea of having a commitment to gender equality, and it could come not just from the ERA, but also from ratification of CEDAW. And I think that's something that's very important and can be important for catalyzing the cultural changes that are necessary in order for legal interventions at the level of gender equality to be successful.
Thank you, Julia. Roger Smith?
Well, it's made me think of the politics of gender equality. I would love to have the ERA like Joe. My thought has been that the political effort to get it could probably be more usefully used pursuing other avenues given the obstacles to it. But I am interested to hear of the progress toward reviving the ERA, so I want to think about whether that seems politically viable. And Joe's point that grassroots activism for social change may be more effective than pushing for legislative policies is also an important argument that I'll be thinking about.
David Kivig?
Well, I think some of the suggestions that we need to recalibrate the language of the ERA deserve a lot more thought. And as much as I am confident that another effort to include an equal rights amendment in the Constitution is a goal still to be sought. I'm given a lot of thought to these cautions that have been raised, but I'm also going to be thinking about the international implications. It strikes me at this point that the failure of the United States to adopt an ERA is probably having an effect on some of our Solons up the hill in terms of whether they think it's there is public support for an international treaty.
Joe Freeman?
I think the American people are woefully ignorant of the social programs that you've described and the ways in which they might make it easier to balance work life and family life. And I would love to see one of our millionaires who's looking for a place to spend his money, her money, publicize these programs and the benefits they offer.
I'm writing that down. That's going to be a future topic for a dialogue program, which I produce and host. I like that.
Okay.
I like that. Now, the final word goes to Laurel Bellows, who the president of the ABA, who started things off for us, and she has the unenviable task of trying to take this non-linear 90 minutes of discussion and sum it up. So, Laurel, if you would close out Law Day 2013 here at the
Thanks,
Wilson
John. Actually, I'm looking forward to it in this world of the Wilson Center of open dialogue and actionable ideas, because I think we've come up with a few. So, first of all, I am one of those who was around for the era of the superwoman. You can have it all if you can do it all. The pejorative term, superwoman, as opposed to the aspirational term. I am very, very interested in the concept of an amendment that focuses on access to justice and equality, perhaps, instead of getting into a debate as to who is equal and how, as opposed to comparable. I am most distressed, as I started out, talking about the fact that we are about to experience, as opposed to celebrate, the 50th anniversary of an Equal Pay Act, where women are earning 70 cents on the dollar, and African American women are earning in the 60s, and Latinas are earning in the 50s. That means that equal Equal Pay Day, which we know to be the day up to which women must work in order to earn what men earned in 2012, April 9th this year. But when you're talking to a Latina, that means she would work till June or July in order to earn what a Latino earned in 2012. These are not celebratory times. We have not been celebrating, at least from my perspective, the fact that we have 20 women in our Senate. That is 20 women. That would be 1/5, all right, of women representing us in an important place, and have gone so far backwards as having it to be impossible to pass an equal rights amendment at any context, and impossible to ratify CEDAW, which is truly an embarrassment. So where are we? We are at, I think, a time of action rather than whining, all right? We are definitely at a point where I'm ready for a social movement. And if we need a discussion as to whether it's ERA or access to equality which causes the social movement, I'd like to see that 1 billion rising, which is what the United Nations attempted to have, 1 billion women rising a couple of months ago. I think we can do that. The ABA has been very much in favor of CEDAW for many, many years. Equal Pay Act, everything else about equality is a principle of the American Bar Association, and we right now are calling to action women and men and children around our country to join us on AmericanBar.org and click their heels in favor of a march on Washington, virtual though it may be. All right, just click on AmericanBar.org and find the heels to click to march on Washington prior to August to demonstrate that we, in fact, believe in equality in this country, which I am unfortunately beginning to doubt a little bit unless I see some heels clicking and people marching. So thank you, John Maluski. Thank you, panel, for this extraordinary discussion. And my hope is that it leads to action rather than more talk.
Perfect final words. Thank you.